Case 1. Antoinette Frank. The Restaurant on Bullard Avenue, New Orleans, Louisiana, March 1995. The Kim An Vietnamese restaurant in New Orleans East was a family business. The Vu family had built it with the particular combination of long hours, community relationships, and immigrant determination that defines small restaurant ownership. By the mid-1990s, they were established enough to employ security, and one of the people they trusted to protect their business was a New Orleans Police Department officer named Antoinette Frank. She worked there part-time. She knew the layout. She knew the family. She knew when cash was on the premises and where it was kept. She knew all of this because the Vus had welcomed her, trusted her, and treated her like someone they were glad to have around. On the night of March 4, 1995, that relationship became the thing that got two of them killed. Antoinette Frank joined the NYPD in 1993. Her hiring was, in the department's framing at the time, a point of institutional progress. She was young, black, and female in a department where all three characteristics were underrepresented. But inside the force, colleagues quickly identified serious problems. She was reckless in basic policing situations. Her judgment was erratic, and she had developed a relationship with the criminal world that went far beyond the professional intersection law enforcement requires. The embodiment of that relationship was an 18-year-old named Rogers Lacaze, a drug dealer with no business anywhere near a police station or a patrol vehicle. Antoinette Frank brought him into both. She let him ride in her patrol car. She gave him access to restricted areas. She introduced him to her colleagues as her partner. Experienced officers who witnessed this described it, afterward, in terms that capture how alarming it was in real time. Watching a cop bring a known criminal into the operational world of law enforcement, treating him with a familiarity that had no professional justification. By early 1995, Frank was in serious financial trouble. She was behind on payments, drowning in debt, and looking for a way out. The Kim An restaurant represented, in her assessment, a target of opportunity, a place she knew inside out, with a regular cash presence and a family who trusted her so completely they would not have anticipated what she had planned. She and Lacaze planned the robbery together. Around midnight on March 4th, Frank used her knowledge of the restaurant's layout and her relationship with the family to get inside. She unlocked the door for Lacaze, who entered armed and masked. What happened next crossed the line from robbery to massacre in a matter of minutes. Off-duty NYPD officer Ronald Williams was working security that night. He was Frank's own colleague, a fellow officer, someone she had worked alongside. When he registered what was happening, Frank shot him in the head. He died immediately. The Vu family members present were forced to the floor. Ha Vu, 17 years old, and Quang Vu, 24 years old, were both executed. Their older sister, hiding in the building, survived and escaped, the sole surviving witness to what happened inside that restaurant. 3 people killed, including a fellow officer, by a woman in a police uniform who had been trusted with the security of this family's business. The investigation moved quickly. Lacaze, young and reckless, had talked. Witnesses placed both of them at the scene. Ballistics matched Frank's service weapon. The evidence was extensive and consistent. At trial, the prosecution built a case that went beyond establishing the facts of the night and into the deliberate architecture of the crime. This was not a robbery that went wrong. This was a robbery planned by someone with insider access, insider knowledge, and a complete willingness to kill anyone, including her own partner, who stood between her and the money. The surviving member of the Vu family testified. One line from that testimony stayed with the courtroom, and has stayed with everyone who followed the case ever since. She said that Frank smiled at them while she pointed the gun. She smiled. The jury convicted both Antoinette Frank and Rogers Lacaze. Both were sentenced to death. In Louisiana, women on death row are extraordinarily rare. Nearly 30 years after the murders, Frank remains one of only a small number of women awaiting execution in the state. She has appealed repeatedly, claimed innocence in various forms, and sought clemency. Every effort has failed. The courts have rejected her appeals. The governor has denied clemency. The Wu family, still carrying the weight of what happened in that restaurant on March 4, 1995, has been present and active in fighting to ensure she remains behind bars. As of 2025, Antoinette Frank is still on death row in Louisiana. She has been there for nearly 30 years. The Kim On massacre did specific and lasting damage to the relationship between the Vietnamese community in New Orleans and the police department. It proved, in the most brutal possible way, that the trust a community extends to an officer can be exploited by someone willing to exploit it, and that the most dangerous person in a room is sometimes the one who already knows where everything is kept. If you're new here, welcome to Daily Crime Archive. We cover cases that deserve more than a two-sentence summary: the full investigation, the trial, the systemic context, the victims' lives, the aftermath that the initial news coverage rarely follows. We don't do shock value. We do depth. We are a new channel, and every subscription matters directly. It shapes how YouTube's algorithm distributes this content. If you're watching and you haven't subscribed yet, hit the button and the bell right now. Drop a comment as you watch. Tell us which of these cases you knew going in, and which one you're hearing in this level of detail for the first time. Now, Case 2. Case 2. Ivon Wu. I shot them both. Brooklyn, New York, October 2021. On the evening of October 13, 2021, neighbors on 19th Avenue in Bensonhurst, Brooklyn, heard gunshots. When NYPD officers arrived at the scene, they found one of their own standing outside, hands raised, weapon set aside. Her name was Ivon Wu. She was a 7-year NYPD veteran assigned to the 72nd Precinct. When officers asked her what had happened, she answered in 4 words: "I shot them both." Inside the home were 2 women. Haimei Liang, 24 years old, had been struck in the chest and died almost immediately. Jenny Lee, Wu's former girlfriend, had been shot multiple times but was alive, bleeding on the floor, and would ultimately survive. To understand what happened on that October night, you have to understand the relationship that preceded it. Ivon Wu and Jenny Lee had been together for years. People who knew them described Wu as intensely attached, someone for whom the relationship was, in ways that were becoming increasingly apparent, the emotional center of her life. When the relationship ended, Wu did not accept the ending. She remained fixated on Lee, monitoring her, struggling with the loss in ways that those around her described as crossing the line from heartbreak into obsession. When Lee began seeing someone new, Haimei Liang, Wu's response was not to grieve and move on. Her response was to drive to Lee's home, uninvited, on the night of October 13th. The confrontation inside the house lasted only minutes. By the time it was over, Haimei Liang was dying on the floor. Jenny Lee was bleeding and injured, and Ivon Wu was standing outside in the night air, waiting for the officers she knew were coming, having already decided exactly what she was going to say. The NYPD's internal reaction to the case reflected the specific institutional embarrassment of a situation where a trained armed officer had used the weapon issued to her by the department to settle a personal dispute, killing one woman and nearly killing another in an act that had nothing to do with public safety or law enforcement. At trial, the prosecution focused on the deliberate nature of what Wu had done. She had driven to that address. She had made a choice to enter. She had drawn her weapon. The physical evidence and her own immediate confession removed any factual ambiguity from the proceedings. The defense raised mental health factors and the emotional context of the breakup, arguments that spoke to the complexity of human suffering but did not change the fundamental facts of what had occurred. In June 2024, Wu pleaded guilty to manslaughter and attempted murder. In August 2024, she was sentenced to 27 years in prison. The sentence generated debate. Some argued it was insufficient for a police officer who had killed a civilian with her service weapon. Others pointed to the absence of prior conduct issues and the mental health context. The debate was real, but it existed alongside a starker reality. Shimei Liang was dead. Jenny Lee had survived a shooting, and the families of both women were left to carry that. Wu is currently incarcerated. She will not be eligible for release until she is in her late 50s. Case 3. Valerie Cincinelli. The Wire, Queens, New York, 2019. In April 2019, the FBI had been listening for weeks. The subject of their surveillance was Valerie Cincinelli, a serving NYPD officer assigned to handle domestic violence cases in Queens. She had been with the department since 2007. She presented herself professionally as an advocate for vulnerable people, the kind of officer who understood, from first-hand professional exposure, what it meant to be a victim. What the FBI was recording was Valerie Cincinelli negotiating the murder of two people. One was her estranged husband. The other was a 15-year-old girl. Cincinelli's personal life in early 2019 was in significant turmoil. Her marriage to Isaiah Carvalho Jr. was dissolving into a bitter legal dispute over custody of their child. She was also in a relationship with a man who had his own complications, including a teenage daughter from a previous relationship. For most people, this is the kind of messy, painful, exhausting circumstance that gets processed through lawyers, family support, time, and the eventual re-establishment of ordinary life. Cincinelli's approach was different. According to federal prosecutors, she approached her boyfriend about finding a hitman. The initial target was her estranged husband. She wanted him killed for $7,000. Then she added the teenager, the boyfriend's daughter, the 15-year-old girl, who she apparently viewed as an obstacle in her relationship. She wanted a child killed. What Cincinelli did not know was that her boyfriend had already contacted the FBI. He agreed to wear a recording device and document their conversations. Over weeks of recorded meetings, federal agents collected hours of audio. Cincinelli discussed the logistics of the planned murders, the timing, the methods, the payment. Her tone in those recordings, as described by investigators who reviewed them, was not that of someone in emotional crisis or temporary breakdown. It was practical, matter-of-fact, and detailed. She discussed hiring someone to kill a 15-year-old girl with the same emotional register that one might use to discuss a scheduling conflict. One federal agent summarized it afterward by saying it wasn't just the murder-for-hire plot that stunned investigators. It was the inclusion of the teenager. That was when they understood they were dealing with something beyond ordinary domestic homicide planning. On May 17, 2019, the FBI staged a fake crime scene. An agent called Cincinelli's boyfriend posing as the hitman, reporting that the job was done. Cincinelli believed her husband had been murdered. Shortly after, agents raided her home. Her phone contained messages confirming the plot, discussing payments, and, in a detail that hardened even experienced investigators, complaining about the cost of having a child killed. The case became national news immediately. NYPD officers had committed crimes before, but an officer plotting the murder of a teenager she viewed as personally inconvenient was a category of case that produced a specific, visceral public response. Cincinelli's defense argued she had been manipulated, that her words had been exaggerated in context, that she had never truly intended for anyone to die. The FBI recordings made that argument difficult to sustain. Facing overwhelming evidence, Cincinelli pleaded guilty in April 2021, but to a significantly reduced charge. She pleaded guilty to obstruction of justice, not to the murder-for-hire counts. The heavier charges were dropped as part of the deal. On October 29, 2021, she was sentenced to 48 months in federal custody. The sentence generated significant outrage. Critics argued that 4 years was inadequate for someone who had plotted 2 murders, including the killing of a child, and who had done so while employed as a law enforcement officer specifically assigned to protect domestic violence victims. Cincinelli was released in 2024 after serving her sentence. She is currently a free woman. Isaiah Carvalho survived. The teenage daughter who had been placed on a murder contract survived. Neither of them will fully escape the knowledge of what was planned for them. 3 cases in, and the range of what these cases represent is already wide. A massacre planned from the inside, a jealousy killing, a murder-for-hire plot targeting a child. 7 more cases to go, each one different, each one with its own specific dimensions. If you're watching Daily Crime Archive and you haven't subscribed yet, do it now. We're a new channel, and every subscription directly shapes how this content reaches more people. Hit the bell. Drop a comment. We read everything. Let's continue. Case 4. Amber Guyger. The Wrong Door. Dallas, Texas, September 2018. On the evening of September 6, 2018, Botham Jean was in his apartment in the Southside Flats complex in Dallas. He was 26 years old, an accountant at PricewaterhouseCoopers, a graduate of Harding University, and a committed member of his church community. He was, by every account of every person who knew him, a man with a bright future and a gentle presence. That night, he was sitting on his couch eating a bowl of ice cream. He was killed in his own living room. Amber Guyger was a 4-year veteran of the Dallas Police Department who lived in the same apartment complex as Jean. On September 6th, she had worked a long shift and returned to the building exhausted, sometime around 10 p.m. What she told investigators, and what became the core of her defense, was this. She had parked on the wrong floor, walked to what she believed was her own apartment, found the door ajar, entered believing she was walking into a burglary, ordered the person she saw inside to show his hands, and fired her service weapon twice within seconds. She was in the wrong apartment, the door above her own, the apartment of Botham Jean. Jean was struck by one of the shots. He died at the scene. The immediate institutional response from the Dallas Police Department treated the shooting as a tragic accident, an exhausted officer making a devastating navigational error. The investigation's initial framing leaned heavily on the human error narrative. The public response was different. Critics pointed to the physical conditions of the building. Jean's apartment had a bright red welcome mat outside his door, something Guyger's apartment did not have. The furniture inside was arranged differently from hers. There were sensory differences between the 2 units that, they argued, a trained police officer should have registered. The central question was not whether Guyger had made a mistake. It was whether the mistake rose to the level of criminal recklessness, and whether the use of lethal force, under those circumstances, constituted manslaughter or murder. Prosecutors, as the investigation developed, upgraded the charge from manslaughter to murder. Text messages recovered from Guyger's phone during the investigation introduced a separate layer of context. The messages, including communications with a fellow officer with whom she was having an affair, painted a picture of a person whose professional and personal boundaries had become significantly blurred. Prosecutors used this material to argue that Guyger was not simply an exhausted officer who made an error. She was someone whose judgment and focus had been compromised in ways that went beyond one bad night. The trial began in September 2019. It was one of the most closely watched police accountability cases in Texas in years, and it played out against the backdrop of a national conversation about police use of force and race. Botham Jean was black, Amber Guyger was white. That shaped how the case was perceived across the country. The defense argued exhaustion, confusion, and honest mistake. They presented the wrong apartment scenario in detail, emphasizing the genuine disorientation that can accompany extreme fatigue. The prosecution argued that even accepting the wrong apartment premise entirely, Guyger's failure to register clear evidence that she was not in her own home, combined with the speed with which she used lethal force without adequate assessment, met the legal standard for murder. Botham Jean's mother, Allison Jean, testified about her son. She described a man of deep faith, genuine warmth, and a future that had been erased in seconds by someone who had not done the basic work of confirming her situation before pulling a trigger. On October 1, 2019, the jury found Amber Guyger guilty of murder. The judge sentenced her to 10 years in prison. The sentence produced its own wave of reaction. Jean's family and many supporters had expected significantly more. Legal commentators pointed to the jury's discretion in sentencing and the genuine complexity of the case's circumstances. The moment that traveled furthest, however, was not the verdict or the sentence. It was what happened immediately after sentencing, when Botham Jean's younger brother Brant stood up in the courtroom, addressed Guyger directly, told her he forgave her, and asked the judge if he could embrace her. The judge said yes. The image of that embrace circulated globally. It generated every possible response: profound emotion, anger, debate about what forgiveness means, debate about what accountability requires, debate about whether grace freely given was something a convicted killer had earned. Brant Jean's choice was his own. The conversation it generated belonged to everyone. Guyger appealed her conviction. In November 2021, the Texas Fifth Court of Appeals upheld the verdict. In March 2022, the Texas Court of Criminal Appeals declined to review it. In November 2022, the United States Supreme Court declined to intervene. In October 2024, she was denied parole. Her next parole review is scheduled for 2026. Botham Jean was eating ice cream in his own home. He was 26 years old. Case 5. Nomia Rosemary Ndlovu, the insurance killer, South Africa, 2012 to 2018. Between 2012 and 2018, a South African police service sergeant named Nomia Rosemary Ndlovu lived what appeared, from the outside, to be a conventional professional life. She wore her uniform. She patrolled her community. She performed the duties her position required. During those same 6 years, she orchestrated the murders of 6 people. All of them people who trusted her. All of them killed for insurance money. Ndlovu had joined the South African Police Service in 1994, during the country's transformation period following the end of apartheid. She was outwardly a functioning, if private, member of her department. What colleagues did not know was that she had been quietly, systematically taking out life insurance policies on the people closest to her, family members, her boyfriend, relatives, and building a plan to convert those policies into cash. The first victim was her cousin, witness Madala Homu, in 2012. He was found murdered, bludgeoned, and left near Olansfontein. Investigators at the time categorized the killing as one of the violent crimes that occur with devastating frequency in South Africa. When Ndlovu collected insurance payouts following his death, it raised no immediate alarm. In 2013, her sister Audrey fell mysteriously ill and died. Ndlovu filed insurance claims. In October 2015, her boyfriend, Maurice Mabasa, was ambushed and stabbed more than 80 times. The ferocity of the attack was extreme, even by the standards of violent crime. Ndlovu collected insurance policies worth more than 400,000 rand. She mourned publicly. She filed her claims. Over the years that followed, she extended the killing to her niece, her nephew, and her own sister's children. Each death was framed as random violence in an environment where random violence is tragically common. Each time, she collected. Each time, no single authority connected the pattern of deaths to the pattern of payouts. What ended it was her attempt to kill one target too many, and a tactical error in how she recruited. In 2018, Ndlovu hired hitmen to murder her elderly mother. The plan was to burn the house down with her mother inside and collect on the life insurance policy. The men she approached turned informants instead. They recorded her. In the footage played at trial, Ndlovu could be heard calmly describing exactly how the murder should be carried out: the fire, the timing, the logistics, and negotiating the price for her mother's death with the same composure one might bring to any ordinary business transaction. The recording was the final piece investigators needed to build the full case. Her arrest stunned the country. A police sergeant with a 6-year body count, hidden behind a uniform and an insurance portfolio. The media called her the insurance killer. Prosecutors presented a case built on insurance documents in her handwriting, financial records showing payouts, the recorded conversation about her mother's murder, and testimony from the hitman she had tried to recruit. On October 22, 2021, the verdict was delivered. Nomia Rosemary Ndlovu was found guilty of 6 counts of murder, attempted murder, defeating the ends of justice, and fraud. On November 5, 2021, she was sentenced to 6 life terms in prison, plus additional time for the fraud charges. She showed almost no emotion as the sentence was read. As of 2025, Ndlovu is incarcerated in a South African prison, serving 6 consecutive life sentences. She will not be released. Her case is the one on this list that most directly illustrates the specific operational advantage that a police career provided to a criminal. She understood investigations. She understood what evidence looks like and how it is gathered. She understood that in an environment of high violent crime rates, individual deaths are easy to lose in the aggregate. She used all of that knowledge over 6 years to kill 6 people without triggering the coordinated investigative response that might have stopped her sooner. Case 6. Karen Reed, The Blue Wall and the Question Nobody Can Answer. Canton, Massachusetts, January 2022. This case is different from every other one on this list. It is different because the central question, the question of what actually happened, has not been resolved. It is different because the legal proceedings have produced not a conviction, but a mistrial. And it is different because the competing narratives at the center of the case do not merely disagree about the defendant's guilt. They disagree about whether the criminal justice system itself is functioning honestly. We are presenting this case with those complexities intact, because flattening them would misrepresent what this case actually is. In the early morning hours of January 29, 2022, Boston police officer John O'Keefe, a 16-year veteran, 46 years old, respected by his department and loved by his family, was found unresponsive in the snow outside a home in Canton, Massachusetts. The home belonged to another law enforcement officer. O'Keefe had injuries on his body, cuts, bruises, and marks that medical examiners would determine were consistent with bite wounds. The official cause of death was hypothermia and blunt force trauma. He was found in the snow, in winter, with injuries on his body. He was dead. Karen Reed was his girlfriend. She had been with him the previous evening. She was quickly identified as the primary suspect. The prosecution's theory of the case is as follows. Reed and O'Keefe had been out drinking. By the early morning hours of January 29th, tensions between them had escalated. When they reached the Canton address where a party was being held, Reed dropped O'Keefe off and drove away. But something happened in that moment. The prosecution argues she was drunk, angry, and reckless, and that as she sped away, the rear of her Lexus SUV struck O'Keefe, knocking him down and leaving him unconscious and bleeding in the snow. They argue she did not stop, did not call for help, and drove away while he died. The forensic evidence the prosecution has presented includes damage to Reed's taillight, consistent with an impact. Fragments of material they argue came from her vehicle found near O'Keefe's body, and evidence of her intoxication that night. Karen Reed's defense presents a fundamentally different account. Reed has maintained consistently and publicly that she is being framed. Her defense argues that O'Keefe was assaulted inside the house by other officers who were present at the party, that his body was subsequently moved outside to conceal the crime, and that the investigation against Reed has been deliberately shaped to protect those responsible. The defense has pointed to what they characterize as contaminated or manipulated evidence, a flawed chain of custody for forensic materials, and investigative decisions they argue cannot be explained by ordinary incompetence. They have accused the Canton Police Department, and by extension elements of the Massachusetts State Police, of constructing a false case against an innocent woman to shield law enforcement personnel who were actually responsible for O'Keefe's death. The public response to this case has been unlike almost anything in recent Massachusetts true crime history. Reed supporters have organized. They have maintained a public presence outside the courthouse. They have formed advocacy groups. They have amplified the defense's accusations about institutional corruption on social media, through podcasts, and through sustained community organizing. The case has generated genuine division. People who know the same set of facts have reached completely opposite conclusions about what those facts mean. In June 2024, after weeks of testimony and days of deliberation, the jury deadlocked. 11 jurors voted to acquit. 1 voted to convict. The result was a mistrial. Reed walked out of the courthouse, not acquitted, but not convicted. Prosecutors announced immediately that they would retry the case. What makes this case so difficult to simply report is that the two competing narratives are not equally weighted in terms of evidence. But neither is the government's case without the vulnerabilities the defense has identified. There are questions about the investigation that legitimate journalists and legal observers, not just Reed supporters, have raised. What is not in dispute? John O'Keefe is dead. He was a decorated officer. His family has spent 3 years without him. What is in dispute? Everything else. The retrial will determine whether Karen Reed is convicted of his murder, acquitted of it, or whether the system produces another outcome that leaves this central question unresolved. As of 2025, the case is pending retrial. 6 cases in, 4 more to go. We've covered a massacre planned from the inside of a security role, a jealousy killing, a murder-for-hire plot targeting a teenager, a wrong apartment shooting that sparked national debate, a 6-year insurance killing spree hidden behind a police uniform, and a case where the central question of guilt or innocence is still being fought in the courts. Daily Crime Archive covers cases like these because they deserve the full treatment. Not a headline, not a 2-minute segment. The whole story. If you haven't subscribed yet, do it now. It directly impacts how many people find this channel. And check the pinned comment after the video for a full status update on every case we cover today. 4 more. Let's finish this. Case 7. Alfreda Fluker. The Parking Lot in Germania Park, Birmingham, Alabama, April 2020. On the night of April 10, 2020, past midnight, a parked car sat in Germania Park in Birmingham, Alabama. Inside were Sergeant Mariel White, a respected Birmingham Police Department officer, and his girlfriend, Kenesha Nicole Fuller, 39 years old. Neither of them saw the shooter coming. Bullets tore through the vehicle. Fuller was struck in the head and chest and killed instantly. White was hit multiple times and left critically injured but alive. The shooter was Detective Alfreda Fluker, a 15-year veteran of the Birmingham Police Department who worked in the Crime Reduction Unit, one of the department's most demanding assignments. She had been, by every professional account available, a capable and dedicated detective. She had also been in an intimate relationship with Mariel White. The relationship between Fluker and White had been volatile and had ended. When White began seeing Fuller, Fluker did not accept the conclusion the situation implied. She began tracking White's movements. By the night of April 10th, she knew where he was and who he was with. She parked near the vehicle. She did not approach. She did not announce herself. She did not attempt any form of confrontation. She opened fire. Fluker was arrested within hours. The investigation was brief because the evidence was immediate and overwhelming. Ballistics tied her service weapon to the shooting. Phone records placed her near the scene, and Mariel White, when he recovered enough to speak, identified her. Birmingham Police Chief Patrick Smith addressed the public with what was described as visible personal distress. He acknowledged what the department was feeling. A detective they had trusted, trained, and deployed against the city's most serious crime had committed exactly the kind of crime she was supposed to prevent. At trial in 2023, The prosecution presented a case built on ballistics, phone records, and White's testimony. They argued this was not an impulsive, emotional breakdown. Fluker had tracked White. She had gone to that location with her weapon. She had opened fire on a parked vehicle containing a man who could not see her coming and a woman who had done nothing to her. The defense characterized it as a crime of passion, the complete emotional collapse of a woman whose personal and professional worlds had merged in ways that made the loss of the relationship catastrophic. The jury convicted Alfreda Fluker of capital murder for the killing of Kenesha Fuller and attempted murder for the shooting of Mistrial White. She was sentenced to life in prison without the possibility of parole. As of 2025, Fluker is serving her sentence in an Alabama state prison. The woman who spent 15 years investigating violent crimes is now incarcerated for committing one. Case 8. Lawrencia, Bembenek. The case that never closed. Milwaukee, Wisconsin, July 1981. This case is now more than 4 decades old, and it remains unresolved in the most fundamental sense. There is still no definitive public consensus on whether the woman convicted of the crime actually committed it. We are presenting the case fully, with both the prosecution's case and the defense's counter-argument, because collapsing the complexity into a simple guilty or not guilty frame would be dishonest to the history. Lawrencia Bembenek, known publicly for most of her adult life as Bambi, a nickname she neither chose nor welcomed, was born in 1958 in Milwaukee, Wisconsin. She was intelligent, ambitious, and strikingly attractive, and in her early 20s she briefly worked as a Playboy bunny at the Milwaukee Playboy Club, before redirecting her ambitions toward what she saw as more meaningful work. In 1980, she joined the Milwaukee Police Department. Her time on the force was short and contentious. Bembenek was outspoken about what she described as a culture of sexism, corruption, and misconduct within the department. She accused colleagues of covering up illegal activity, drinking on duty, and operating with impunity. Rather than being received as a whistleblower, she was received as a problem. Less than a year after joining, she was fired during her probationary period. By then, she had married Fred Schultz, a Milwaukee police detective who had recently divorced his wife Christine. The marriage brought Bembenek into direct contact with the financial and emotional aftermath of that divorce. Fred was paying child support and alimony to Christine, and the two households existed in a tense proximity. On the night of July 3, 1981, Christine Schultz was murdered in her home. She was tied up, gagged, and shot once in the chest with a .38 caliber handgun. Her 2 young sons discovered her body. The investigation focused on Bembenek almost immediately. Prosecutors constructed a motive built on financial resentment. She wanted Christine gone so Fred would be free of the financial obligations tying him to his ex-wife, and so that Lawrencia would no longer feel overshadowed. They presented fiber evidence from green jogging pants found in Bembenek's home that they argued matched fibers at the crime scene. The defense challenged the evidence aggressively. The jogging pants, they argued, had never been tested for gunpowder residue, and their chain of custody was poorly documented. Bembenek supporters argued the most likely source of the evidence problems was the Milwaukee Police Department itself, a department that, they argued, had substantial institutional motivation to frame a woman who had publicly accused them of corruption. Despite the evidentiary challenges, the jury convicted Bembenek in 1982. She was 23 years old. She was sentenced to life in prison. The years that followed were extraordinary in multiple dimensions. Bembenek became a media sensation, not because the public was indifferent to Christine Schultz's murder, but because the combination of her personal history and the genuine questions about the evidence produced a significant movement of people who believed she had been wrongly convicted. Supporters held rallies. Tabloids ran stories. The case became a cultural touchstone. In 1990, Bembenek escaped from prison with the assistance of her fiancé. The two were captured in Canada 3 months later. The escape deepened the public fascination with her case and, for many observers, reinforced the impression that she was desperate rather than guilty. In 1992, her conviction was overturned due to prosecutorial misconduct and evidence handling failures. Rather than face a full retrial, Bembenek pleaded no contest to second-degree murder and accepted a reduced sentence. She was released after serving approximately 10 years. For the remainder of her life, she maintained her innocence. She gave interviews. She wrote a memoir. She built a following of people who believed the Milwaukee Police Department had framed her to silence a whistleblower. She died in 2010 at the age of 52, in poor health, and without the exoneration she had sought. Christine Schultz's family maintained throughout that Bembenek was guilty. Christine's sons, who found their mother's body, grew up carrying that experience. Both things are true simultaneously. There were genuine failures in the handling of the evidence and prosecution of this case, and Christine Schultz is dead. What Bembenek's case ultimately represents, for the purposes of this list, is a different kind of complexity. Not the clear-cut betrayal of the badge documented in most of the cases we cover today, but an entanglement of a former officer, a corrupt institutional environment, a murder, and a justice system that may have gotten the wrong answer for the wrong reasons, or may have gotten the right answer badly. The distinction still matters, and it is still unresolved. Case 9. Stephanie Moore. The Order to Bite. Tacoma Park, Maryland, September 1995. On the night of September 21, 1995, two men were spotted climbing the roof of a bakery in Tacoma Park, Maryland. Officers responding to the report of a potential burglary confronted the two individuals, Ricardo Mendez and an unnamed companion, on the building. The men, who were unarmed, complied. They came down from the roof. They stood against a fence with their hands raised, ready to be searched and handcuffed. They were in custody. The situation was controlled. Stephanie Moore was a K-9 handler with the Prince George's County Police Department, paired with a German Shepherd trained for tracking and suspect apprehension. She had been with the department since 1991 and had developed a reputation as someone who was, in the assessments of people who worked alongside her, too eager to escalate. On that September night, with two unarmed, surrendered men standing against a fence with their hands up, Moore gave her dog the command to engage. The German Shepherd lunged at Ricardo Mendez and bit into his leg. He screamed. The dog tore through muscle tissue, causing injuries that left permanent scars. Other officers present at the scene would later testify that there had been no justification for the deployment. The suspects were not resisting, not fleeing, and not presenting any threat. Moore let it happen anyway. The incident did not produce immediate criminal consequences for Moore. The 1990s were a different moment in the public accountability of law enforcement, and allegations of excessive force in Prince George's County, a department with a documented history of civil rights complaints, were not unusual enough to guarantee federal attention. What eventually forced accountability was a federal investigation that opened years later and looked at the department's broader pattern of excessive force. Moore's case came under scrutiny as part of that investigation. In 2000, she was charged in federal court with violating the civil rights of Ricardo Mendez under color of law. The prosecution characterized her decision to release the dog on a surrendered, unarmed man as sadistic. Not a split-second judgment call in a dangerous situation, but a deliberate choice to inflict pain on someone who had no ability to resist. Fellow officers testified against her. They described the situation as controlled when she gave the command. Their testimony directly undermined the defense's claim that Moore had acted out of reasonable concern that the suspects might flee. In 2001, the jury found Moore guilty of depriving Ricardo Mendez of his civil rights under color of law. She was sentenced to 10 years in federal prison. In 2020, she received a presidential pardon. To her supporters, it represented the vindication of an officer who had been scapegoated by a federal investigation targeting the department. To civil rights advocates, it was an insult to the victim and to the principle that officers who abuse their authority should face consequences. Ricardo Mendez carried the physical scars of that night for the rest of his life. He had surrendered. He had raised his hands. He had done everything that a person in his position is supposed to do to signal compliance and avoid harm. He was bitten anyway because Stephanie Moore wanted her dog to get a bite. Case 10. Stephanie Lazarus, 23 years, Los Angeles, California, February 1986 to June 2009. On the morning of February 24, 1986, John Rutten left for work from the home he shared with his wife, Cherie Rasmussen, in Van Nuys, California. When he returned that evening, Cherie was dead on the living room floor. She had been beaten. She had been bitten. She had been shot 3 times with a .38 caliber revolver. The crime scene had been staged to look like a burglary. A few items removed, signs of forced entry manufactured. Cherie Rasmussen was 29 years old. She was the director of nursing at Glendale Adventist Medical Center, a woman described by everyone who knew her as brilliant and compassionate, and at the beginning of a career that was already distinguished. The investigation found no arrest. The case went cold. Before her marriage to John Rutten, John had been in a relationship with a woman named Stephanie Lazarus. They had met at UCLA. When John ended the relationship and moved on, eventually meeting and marrying Cherie, Lazarus did not accept the ending with equanimity. She remained, by the accounts of people who observed her behavior, fixated on John in ways that went beyond ordinary heartbreak. Cherie herself had confided to her father that she was troubled by Lazarus's behavior. She told him that Lazarus had appeared uninvited at her workplace. She said Lazarus had told her directly, "If I can't have John, nobody else will." Despite these documented concerns, when the LAPD investigated Cherie's murder in 1986, they did not pursue Lazarus as a serious suspect. She was one of their own. She was an LAPD officer. The investigation filed away without an arrest. Stephanie Lazarus built a career. Over the 23 years following Cherie's murder, she rose through the LAPD to the rank of detective. She worked in the elite art theft unit. She was respected by colleagues. She married another officer. She adopted a daughter. She had a house in the suburbs. She was, by every external measure, a successful professional and a model member of her department. All of that time, she was carrying the secret of what she had done in that Van Nuys apartment. The break came in 2005. Cold case investigators, reviewing old files and applying DNA technology that had not existed in 1986, re-examined the bite mark on Cherie Rasmussen's body. DNA analysis of saliva retrieved from that mark revealed that the attacker had been a woman. The burglary gone wrong theory collapsed entirely. This was a personal killing. Investigators began revisiting Cherie's background, her marriage, her prior relationships, any documented conflicts. The name Stephanie Lazarus appeared in the record. Cherie's documented concerns about her, the reported confrontation at her workplace. Investigators worked quietly and carefully. They knew Lazarus still carried a badge and had access to law enforcement databases. They followed her. They collected DNA from a discarded coffee cup. They tested it against the bite mark sample. It matched. On June 5, 2009, investigators called Lazarus into an interrogation room under the pretense of asking for her assistance on an unrelated case. They were LAPD officers. She was an LAPD detective. She had no reason to think the meeting was about her. The video of that interrogation has been watched millions of times. She was calm, initially, cooperative. When investigators began asking questions that were clearly not about the case they had described, she shifted, confused at first, then increasingly tight. When they revealed what they had, she did not break dramatically. She did not confess. She sat in the room with the knowledge of what was happening, and the 23 years of practiced concealment that had gotten her there. She was arrested, charged with first-degree murder. The trial began in 2012. 26 years after Cherie's death. The prosecution presented the DNA evidence from the bite mark. They presented Cherie's documented fears about Lazarus. They presented the staged burglary as the work of someone who understood how crime scenes are read by investigators, because she was one. The defense argued evidence contamination, chain of custody failures, and the possibility of another female attacker. The jury did not find those arguments sufficient. On March 8, 2012, Stephanie Lazarus was convicted of first-degree murder. She was sentenced to 27 years to life in prison. She will not be eligible for parole until the 2030s. A 2024 parole eligibility review pushed that date back further. For Cherie Rasmussen's family, the verdict was the vindication of something they had believed for years. Cherie's father had insisted from the beginning that Stephanie Lazarus was responsible. For more than 2 decades, no one had acted on that belief. Cherie was 29 when she was killed. She died in her own home on a morning when she thought her husband had gone to work, and she was safe. The woman who killed her spent the next 23 years walking into police stations, sitting in courtrooms, investigating crimes, and living a life that Cherie never got to live. She was caught, not by a witness, not by a confession, not by a mistake that could have been avoided. She was caught by a technology that didn't exist when she pulled the trigger. 10 cases. 10 women who wore law enforcement credentials and used them to kill, to plan killings, to torture, to conceal, or to open doors that should have stayed closed. The range of what these cases represent is deliberately wide. Antoinette Frank's massacre was planned and executed with insider knowledge. Ivon Wu's crime was a product of obsession and rage. Valerie Cincinelli's plot was cold and calculated, targeting a child. Amber Guyger's killing was the result of failures of judgment and training that the legal system categorized as murder. Nomia Ndlovu's 6-year spree was a long-game financial crime, disguised as random tragedy. Karen Reed's case remains, as of 2025, legally unresolved. Alfreda Fluker killed out of jealousy with a weapon her career had provided. Lawrencia Bembenek's conviction was overturned amid evidence of prosecutorial misconduct, and the case has never been finally settled. Stephanie Moore chose to harm a surrendered man because she wanted to. And Stephanie Lazarus killed a woman for having the life she wanted, then spent 23 years inside the department that was supposed to be looking for her. What they share is the credential, the badge, the uniform, the license to carry a weapon, the institutional authority that comes with law enforcement status. In each case, that credential either enabled the crime, protected the perpetrator from immediate accountability, or complicated the investigation in ways that would not have existed if the perpetrator had been an ordinary civilian. That is the specific horror of these cases. Not that women can commit violent crimes, that is not a discovery, but that the systems designed to catch violent criminals can be inhabited by the criminals they're designed to catch, and that those systems' internal cultures of loyalty and protection can slow the accountability that should follow. The cases on this list, where accountability came fastest, were the ones with the clearest evidence and the fewest institutional complications. The ones that took decades were the ones where the perpetrator wore the same uniform as the investigators. That is not an argument against law enforcement. It is an argument for the sustained, honest functioning of the mechanisms that are supposed to hold it accountable. 10 cases. 150 minutes. If you made it to the end of this one, thank you. These cases take time to cover properly, and the fact that you stayed is exactly why this channel exists. Daily Crime Archive is new, and your subscription matters directly. Hit subscribe. Turn on the bell, and check the pinned comment below for the full current status on every case we covered today, where each person is as of 2025, what sentences are being served, and what cases are still pending. Drop a comment. Tell us which of these 10 cases you knew in depth, and which one you want us to dedicate a full standalone episode to. We read every comment, and it shapes what we cover next. We'll see you in the next one.